Thank you, Fred. My Lord Chief Justice, my Lady Deputy Chief Justice and Judges of the Supreme Court, my submission before this Honorable Court this morning touches on a single issue, which is that there isn't a valid petition before this court, and the three petitioners herein, namely Honorable John Harun Mao, Njonjo Mwe, Khalif Khalifa, lacks the constitutional locus standi to institute a petition under Article 140, challenging the election of Honorable Uhuru Kenyatta, the third respondent herein, as President of the Republic of Kenya. My Lord, it's my submission that from the pleadings of the petitioners, it is quite clear that they have not participated in the election of 26 October. And I will show you that they do not, or they are not a person under Article 140 of the Constitution. They are not that person Article 140 refers to. My Lords, it's my submission that a person who under Article 140 of the Constitution files a petition challenging the election of a candidate must not do that as an academic exercise or as a game of chance or as a proposal for donor funding or become a national irritant. That person who files a petition under 140 must have a genuine grievance. He must state before this court that his right as a voter who participated in the election that's been impugned was violated by the conduct of the first and second respondents. My Lord, he must show this court that a right bestowed upon him by this Constitution and a right that he exercised was infringed so flagrantly that he has now a grievance under Article 140, and he qualifies to be that person. My Lord, if I read for you, and I'm sure you have read so many times, Article 141 says, a person may file a petition in the Supreme Court to challenge the election of the president. And my Lord, if we don't adopt the judgment, the dissenting judgment of my Lord Justice Ojwang at paragraph 215 of the Raila 2017, my Lord Justice Ojwang says that we must, in interpreting the terms of the Constitution, break down the provisions in an article. In other words, we need to do a proper interrogation of who a person under Article 140 is. My Lord, if we don't do that, we can say that a person, for example, include an American tourist on a visa, is a person. A Ugandan will be a person. Okwala Cooperative Society is a person. Under Article 260, my Lord. The only definition of a person, my Lords, is Article 260, which says, my Lord, a person includes a company, association, or other body of persons, whether incorporated or unincorporated. So, my Lord, if we leave the person under 140 without further interrogation, it will lead to an absurdity, because Article 260 defines a person to include both incorporated, unincorporated, and even a body corporate. So, my Lord, this court must now look for the meaning of who is that a person, because it cannot be either a foreigner or a company like Barclays Bank, my Lord, because Barclays Bank can, if we say a person, if we leave it to a person, even a bank can challenge the election of a president. Where do you find that a person, my Lord? My Lord, it's my humble submission that that person who can challenge a presidential election under 140 is a person, not just a registered voter, but a person who exercised the right to participate in that election under Article 38(2) of the Constitution. A person, my Lord, who participated in exercising his right. So it is only when you participate in that that you become the person who has the locus standi to challenge. My Lord, it's a common ground that the three petitioners have not pleaded in their petition that they participated in their election. All the three petitioners, my Lord, state that they are voters, and my Lord, the court will take judicial notice that the third petitioner, Khalif Khalifa, even filed a petition before this court to stop that election. My Lord, why do we go back to Article 38(2) of the Constitution? Because Article 38(2) of the Constitution defines or breaks down the person who is entitled to vote in an election. It says every citizen, so you must be a citizen. That person is now defined or qualified further under Article 38(2). It says every citizen has the right to free, fair, and regular elections based on universal suffrage and the free expression of the will to elect any person. So, my Lord, where you must be a citizen of Kenya who has the right to vote and who has voted for you to have the locus to complain about an election under 140, my Lord. Foreigners, my Lord, or juridic persons with corporate, whether corporate or incorporate, are excluded by Article 38(2). So, my Lord, it's my humble submission that Article 140 of the Constitution must be read, explained, and interrogated with reference to Article 38 of the Constitution. My Lord, I will take you back to the judgment of this court that was delivered about a month ago to show the centrality, the unanimity between the majority and the dissent on the centrality of Article 38 of the Constitution. And my Lord, I will first start with the majority. And the first reference, my Lord, I will make is paragraph 372 of the majority, my Lord, where you said, my Lord, that you said that Article 38 of the Constitution provides that every citizen is free to make a political choice, which includes the right to free, fair, and regular elections based on universal suffrage and the free expression. This, you said, my Lord, is the mother principle. It's really the substratum upon which the entire election laws in this country is premised on. And then you said, my Lord, that this mother principle must be read together with the other provisions of the law. The other one, my Lord, is Article 371 of the Constitution. Sorry, my Lord, Article 372, paragraph 371 of the majority judgment, where again this court emphasized, and you said, my Lord, none of the factors highlighted by the parties can be viewed in isolation, for to do so we risk cannibalizing the sovereign process. Elections are the purest way through which the people express their sovereignty, and our Constitution, my Lord, you said, upon the immutable principle of the sovereign will. The fact that it is the people and they alone in whom that power resides. My Lord, if I go to the dissent by my Lord Justice Ojwang, I start with paragraph 164, where my Lord addresses that issue in great detail. Then, my Lord, I take you to paragraph 165, 169, and lastly, 198. And in those four paragraphs, my Lord Justice Ojwang emphasized the centrality of Article 38. But my Lord, the judgment that captures this most strongly and in detail is the dissent by my Lady Justice Njoki. And I start, my Lord, with paragraph 17, where my Lady stated rightly that Article 38 or an election petition is a right-centric. You must litigate over a grievance that has arisen pursuant to your exercise of your right under Article 38. Then, my Lady, at paragraph 15, 16, 17, 24, 27, 28, 35, 38, and the two last paragraphs, my lords and my ladies, I will just emphasize because I think the words are very strong. If you look at paragraph 40, and I will read this, my lord. This is what my Lady Justice Njoki said. She says, that's paragraph 40. The conclusion may therefore be drawn that fundamental rights constitute the foundation of any constitution, and any accompanying value and principles are to be complementary and not to be detracted from the constitution. The rights in Article 38 remain central to any election cause, and it is a claim of the violation of those rights that ought to take center stage in such a cause, and not the form that accompanies it in the periphery. So, my lord, you must have a cause of action under Article 38(2). You must have exercised that cause of action or right under Article 38(2). Then you must be aggrieved by how your right was handled by the first and second respondents for you to qualify as any person may under 140 bring. My lord, if we don't do that deconstruction of Article 140, then you will be allowing any person to pursue an election petition either as a game of chance. A foreigner on a visa can file that suit just to disrupt the process, or anybody with malafide intention can file that suit. And my lord, at paragraph 41, my lady continued and said, having determined that election causes are right-centric in nature, and having discussed the centrality of every citizen's right to vote in a free, fair, and regular elections based on universal suffrage and the free expression of the will of the electors of any elective public body or office established under the Constitution, I now evaluate the alleged violation under Article 81 and 86. Rightly so, my lord, because you can only evaluate the wrongs that have occurred under 81 and 86 if you establish that a right under 38 too had been violated. My lord, if I go to the second phase of my submission, my lord, I will start with the sentence my favorite sentence in that judgment, which is at paragraph 394 of the majority judgment. Just one sentence, my lord. And my lord, that sentence is the one that reads, the greatness of the nation lies in its fidelity to the Constitution and strict adherence to the rule of law. My lord, I mean, that was a war cry in my submission. It was a call of arms by this court. And my lord, it is a phrase, if internalized and effectuated by this court, can be the panacea to the many ills of this country. But my lord, if there is one institution that one sentence applies to, it is this Supreme Court. if you internalize that and if it becomes the article of faith of this court, that the greatness of the nation lies in the fidelity of the Constitution and strict adherence to the rule of law, then many of the ills of this country, through your example, will be cured, my Lord. My Lord, I would like, or I ask the registrar if he can if you distribute volume 5 of the list of authorities, because, my Lord, when I'm reading this on constitutional interpretation, I would like, my Lord, if possible, for you to have this. And my Lord, the first authority I would like to read for you is an article by Professor Carl E. Clare called Legal Culture and Transformative Constitutionalism. It's this big, so if you don't have, you don't have. Okay, he doesn't have, my Lord. So, my Lord, Professor Carl is a distinguished professor of constitutional law. The article is called Legal Culture. My Lord, it is volume 5 of the third respondent's supplementary list of authorities. It is number 2 in that list, and it appears from page 30 to 73 of the list. My Lord, Professor Carl's article appears from page 31. He's a distinguished professor of law at Northeastern University Law School. And he's a South African, my Lord, so he was writing about the place of the court, especially the Constitutional Court, in interpreting the Constitution of South Africa in light of the transformative nature of that Constitution and the role the court should play. So, my Lord, if you look at page 32 of that list of authorities, you will find where Note 3 ends. The sentence that starts with the end of Note 3, I will read for you what he says. He says, because, my Lord, I'm emphasizing how adherence to that line I have just read applies most strictly to the court itself. This is what he says. Among types of lawmaking, adjudication is, or is supposed to be, the most reflective and self-conscious, the most grounded in reasoned argument and justification, and the most constrained and structured by text, rule, and principle. We must therefore legitimately expect the constitutional adjudication to innovate and model intellectual and institutional practice appropriate to a culture of justification. Continued attention to adjudication should accordingly illuminate South Africa's steps across the bridge, and adjudication uniquely reveals ways in which lawmaking and, by extension, legal practice generally are and or could be a medium for accomplishing justice. My Lord, the second page I will refer to is page 34, line 4. This is what he says. But judges still and always confront the conflicting poles and tension, which we used to call the dialectic of freedom and constraint. On the one hand, there's a grand constitutional text, replete with broad phrases and redolent with magnificent hopes to overcome past injustice and move towards a democratic and caring society. Yet on the other, just about everyone takes for granted that adjudication is not and cannot be infinitely plastic and open-ended, and judges and lawyers are not completely at large to say and do as they please by the lights of whatever personal vision of freedom they hold. My Lord, when I was reading this, my Lord, I remembered what Justice Smokin said some time back about the spirit of the Constitution, that it's not just the good spirit that the Constitution people read into. Sometimes they read the demented spirit, as my Lord put it. So, my Lord, the learned author is saying that it is not whatever personal vision of freedom they hold. A commitment of legal constraint invoked by the mantra rule of law seems to be a foundation of the democratic transition enterprise, respecting particularly the problem of constitutional interpretation by courts. Acting Justice Cambridge, well-noted comment in Zuma case, captures the tension or ambivalence most succinctly. My Lord, let me just read the last paragraph He says, while we must always be conscious of the values underlying the Constitution, it's nonetheless our task to interpret a written instrument. I am well aware of the fallacy of imposing the general language must have a singular objective meaning, nor is it easy to avoid the influence of one's personal, intellectual, and moral preconceptions. But it cannot be too strongly stressed that the Constitution does not mean whatever we might wish it to mean. My Lord, lastly, I will refer you to page 42 of that article. And my Lord, this is very important because there is this fallacy some people subscribe to because that a judgment, because that a constitution of a country like South Africa and Kenya are called transformative constitution. What is the role of the judges? And when I quoted this to a judge or a three-judge bench in the court, in the High Court, and I told them that the role of the court is not to be transformative. That's not your function as a judge. Because if the court says that they will give judgments that are transformative, there is the danger that they will legislate. It is the document that is transformative. It is not the judgment of the court that should be transformative. So, my Lord, this author makes the point that the courts should avoid to deliver transformative judgment. Their function is simply to interpret. Let me read, my Lord, line 7. This is what the learned professor said. He says, but we balk at the idea of transformative adjudication because this suggests an invitation to judges as distinct from legislators to attempt in their work to accomplish political projects. To the contrary, the rule of law ideal enjoins judges to check their politics at the courthouse door. Judges are appointed neutrally to enforce the law set down by others, not to make politics. They are supposed to provide legal interpretation of text, which means filtering out as best as they can their personal or subjective views or what is taken to be the same thing, their political values and ideological misconception. In this respect, mainstream jurisprudence conflates the personal and the political. In all traditional accounts, the rule of law ideal is premised on a radical disjunction between law and politics and a sharp role differential between what judges do and what politicians and political theorists do. So the very idea of transformative adjudication seems to be out of place with liberal legalism. But my Lord, I take the view that even though this court interprets the Constitution, like all constitutional courts, this is a political court. It's a political court that interprets the Constitution. Political not in the sense that it's a player, but because most of the decisions a court of this nature adjudicates are of political nature. And my Lord, I will just quote you a text from one of the most eminent constitutional law experts, which is, my Lord, it's Professor, he's called Professor Jeffrey Goldsworth. My Lord, again, I will just, if you look at volume 4 now, volume 4 of the third respondents, it starts at page 124, and my Lord, it goes to up to page 161. My Lord, Professor Goldsworth says that constitutional courts, especially Supreme Courts, are political courts because they interpret important political questions of the day. But my Lord, he suggests that if you look at, and I emphasize, my Lord, just page 124 and page 125, he emphasized the point, my Lord, that in interpreting the Constitution, because of the powers of this court, let me just read, my Lord, at page 125. This is what he said. That is why political scientists rightly depict constitutional courts as political institutions that wield enormous power. Whatever judicial decisions change the law, judges exercise political power, and when the law is the nation's constitution, they exercise the highest political power that exists in the state. And my Lord, there is no higher power, political power, than the powers you exercise in this court. For instance, the one to invalidate a presidential election. But that is the nature of a constitutional court. My Lord, my time is up, but I will also refer you kindly to also, when you retire, you look at, again, another book by Professor Jeffrey Goldsmith, and it's page 169, my Lord, to page 174. Lastly, my Lord, I will refer you to the eminent Harvard Law School professor, Professor Lawrence H. Tribe, article. It's called Taking Text and Structure Seriously. It's page 202, my Lord, to page 217. But my Lord, I think it will be very unfair for me to conclude this without referring to two authorities by the eminent Chief Justice of Israel on constitutional interpretation. My Lord, I take you back to volume 5. The extract starts from page 91 and ends at 102. But my Lord, can I just emphasize the text that appears at page 96, where the learned CJ refers to what is a purposive interpretation of a constitution. And my Lord, at page 94, where he writes of the interpretation of a constitution, and there's a very, my Lord, there's a very nice language he uses where he says, interpretation, my Lord, is extraction of the meaning of a word from a text. And my Lord, one is you read the learned author, and then you try to extract the meaning of Article 160, my Lord. You will reach, my Lord, the inescapable conclusion that the person referred to as the person in Article 140 must be the person who has exercised a right to vote. When you stayed in your house or made a conscious choice not to vote, and you are entitled to, my Lord, you cannot question the consequences of a process you did not participate. It becomes a purely academic exercise. My Lord, lastly, my Lord, it's my humble submission that this court, as suggested by my Lord Justice Ojwang, should have some joy in constitutional interpretation. There is a feeling in some quarters, probably where I belong, that the courts pay insufficient attention, and you are very modest in your interpretation of the Constitution, my Lord. My Lord, there is a need to break down certain provisions of the Constitution instead of just making a very general statement. My Lord, with that I conclude that this petition before the Honorable Court, for the reasons I have advanced, is a waste of time. It was filed by 3 individuals who failed to even exercise their most civic constitutional right to elect a president of their choice, and they had a wide choice of 8 candidates, including my friend, Dr. Okot. My Lord, the first petitioner, that's Harun Mau, has filed many suits, and some of them, my Lord, that has led to very, very important constitutional judgments. But my Lord, his last petition before this court is nothing more than the fascination of a layman with the magic, the majesty, and the mechanics of the law. As for the second and third respondents, my Lord, 2 very high priests of the civil society, this petition is nothing to do with public interest litigation. It's an innovative and a powerful proposal for donor funding. My Lord, I pray that the same be dismissed with cost. Unless you have any questions, my Lord, that's the end of my submission.
Thank you. Thank you, Senior Counsel.
Hello, the Chief Justice.
Just a minute, Mr. Krago. Before Mr. Ahmednasir,
Yes, my lord.
do you have evidence that they did not vote?
Yes, my lord. That's why I said at the beginning of my submission that, my lord, if you look at Part A of the petition by Njonjo and Mue, they just say that the petitioners are adult Kenyan citizens duly registered as voters. One is registered in Langata constituency, the other is registered in Nyali constituencies. There is no averment that they have participated in this election. There is not a single averment. In fact, my lord, if you look at, I didn't want to take a lot of time on it, but if you look at paragraph 16, paragraph 17, 18U, it's the entire, my lord, the entire petition is premised that there was no election. There was no election. That's the, and the election so-called, which is an alternative to that there was no election. The election so-called was now reached the following constitution. But the first premise is that there was no election. That's what the principle said, my lord. My lord, the same, and let me just help the court, my lord. If you look at Harun Mau's, my lord, Harun Mau's, both his affidavit is very interesting, my lord. It appears at A63. Harun Mau's addresses a lot of issues in detail. For instance, the way he's a stickler of or champion of the rule of law, the way he has never committed a crime. I don't know why you find that very important. The way, my lord, that he participated in the constitutional enactment, the way he has been a member of parliament, the way he has participated in the debates. But, my lord, at the last paragraph, paragraph 140 is the one he says, I make this affidavit on my own behalf as an affected party, being a voter, and a person who respects the constitution and the rule of law. There is not one sentence in that detailed affidavit that gives even all his backgrounds where he says, I went to vote and I'm not happy on how my right to vote was treated, my lord.
Mr. Ahmednasir?
Yes, my lord.
The right to vote also comes with the right not to vote.
Yes.
So if I exercise my right not to vote, are you suggesting that I then cannot come to this court under Article 140? Because I've exercised my right not to vote.
My lord, my lady, the right to vote is a right captured under Article 38. There is no right not to vote. It's not in the Constitution, and you will not find the right, it's not a right not to vote. It's a decision not to vote. You abstain. Yes. So, my lady, when you elect not to vote, you are just invalidating your right to vote. But there is no distinct right called the right not to vote. You are just spoiling your vote. You have elected not to vote. But there is no distinct right called the right not to vote. Because the Constitution gives rights in a positive, tangible manner. But my lord, let me see. I mean, my learned friend just showed me our submission. No, it's an affidavit by Winnie Guchu, my lord. If you look at page 10 of that, paragraph 21F, there's a quotation from a decision in India which talks about that position, my lady. Probably, should I read or will the court read for itself? This is what it says, my lady. It says, all the voters do not always go to the poll. Voting in India is not compulsory, and therefore, no minimum percentage of voters have been prescribed either for treating an election in a constituency as valid or for securing the return of the candidate at the election. The voter may not turn up in large numbers to cast their votes for a variety of reasons, such as agitation going on in the state concerned on national or regional issues, it's a common knowledge that voting and abstention from voting is also the pattern of voting depending upon complex variety of factors which may defy reason and logic. This court has taken judicial notice of the fact that in India, all the voters do not always go to the poll, and that the casting of votes in an election depends upon a variety of factors. But my lord, I think the point, my lady, you are making is, if you elect not to exercise your right and you have slept on it, the consequential factors that are triggered by that, or the consequential factors that are triggered by those who elected to vote, you should sit out in that process. You can't say that I will not participate in this election and then say that this election is wrong because of A, B, C, and D. You are not a participant to that process. You can't challenge that process.
Thank you. Yes.